All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals draw near and give your attention. God save this United States and His honorable court. This honorable court is now in session. Please come to order.
Good morning. We have 3 cases on this morning's calendar, and we'll take them in the order in which they're presented. The first case is ZAID ABED versus United States. Counsel, you may proceed.
Thank you, Judge Glickman, and may it please the court. My name is Greg Lipper. I represent the appellant ZAID ABED. I'd like to reserve 4 minutes for rebuttal. And I will begin with our argument under the Law Enforcement Officers Safety Act, or LEOSA. When Congress enacted LEOSA, it was its manifest purpose was to allow trained law enforcement officers to carry firearms in other states, notwithstanding those states' own laws about the possession, registration, or licensing of firearms. And as both the proponents and the opponents of LEOSA agreed, the purpose of the law was not just to allow law enforcement officers to carry their firearms, but also, if necessary, to use them to defend others or to defend themselves. That is what happened in this case. As when Officer ABED approached the scene leading this case, he had his service pistol holstered. The holster was stored in his, underneath his waistband in his near his front right pocket, with only the handle visible. And just over a minute after arriving, he needed to unholster his service pistol and briefly point it because, as the trial court found, he reasonably and actually found that he faced an imminent threat of death or serious bodily injury. Despite all of
I'm sorry, Mr. Lipper, can you clarify, is this we have factual findings about this, and I understand you're disagreeing with, I guess the sense that if the officer shows the gun, but it was otherwise concealed, that is not what concealed means. Do you understand this to be a purely legal question about the meaning of LEOSA? Or, to what extent do we have to defer to the findings that the judge made? Or do you just think that they're sort of neither here nor there?
I would say it's almost entirely a legal question with one minor caveat. So I'll say the one minor caveat first is that the trial court in the course of ruling that the service pistol was not concealed, suggested that all police officers understand that the way to conceal a firearm is to store it, behind them, within their back. And there was no testimony or other evidence about that in the trial record. So I think to the extent his or the decision depends on that, I think there was no factual basis for it. But I would say other than that, and I think more broadly, this is actually a legal question in a couple of respects. I think the first question is, does LEOSA require 100% concealment at all times? Even the trial court and the government acknowledge that concealment is not required when the service pistol is used in self-defense. I think, we would say, and I think Congress would say, that the 60 or 66 seconds preceding that sort of, the unholstering of the service pistol does not make the possession unlawful when it would otherwise have been lawful, number one. And then number two, even if concealment were required at all times, but other than the sort of immediate act of self-defense, the Congress legislated against a background of in which the meaning of concealment is not one size fits all, as the trial court speculated, that both under different states interpret concealment differently, and several states, as we cite in our brief, will treat a weapon as concealed, even if the holster is visible or the handle is visible. And training manuals, training websites, holster manufacturers will recognize that concealment is considered, the way Mr. Abed had his gun holstered would be considered concealed. In fact, one of the sites that we cite in our brief describes the way that Mr. Abed was holstering his pistol as the most popular method of concealment. Another training website, Lexipol, which I think trains millions of law enforcement and other public safety officers, not only describes a method of concealment in which the weapon is holstered on the front with the handle visible, but actually has a photo of an example of a concealed weapon. And that weapon is, if anything, more visible than Mr. Abed's was, because not only is the handle visible, but the entire holster is visible.
Well, why is that? Why are those considered concealment when they seem to be such a deviation from the common understanding of what it means to conceal something?
Well, I'm actually not sure that, they may be let me say two things. First of all, they may be a deviation from what a layperson would understand to be concealment, or a lay dictionary would understand to be concealment. But Congress, this law was regulating law enforcement officers who are trained in firearms and concealment, and who are, whether or not they're experts per se, they're certainly sort of people in the industry who, in the same way that I'm sure many of the terms that we lawyers and judges use every day, are used in ways that members of the public would find strange. Within our sort of legal community, we understand what they mean and how they're used. And I think there's a similar, you have to approach LEOSA with a similar understanding. And when you have both multiple courts and multiple sort of training manuals with this definition, I don't think you can say that those are outliers. I think those reflect, I think more generally, that there are many means of concealing a weapon. And I think if you look in this case, the committee reports, I think that, they say not only do they want officers to be able to use their service pistols to defend themselves or defend others, but the word, quote, immediately appears. They want officers to be able to respond immediately. And the way that Mr. Abed had his pistol holstered, having it accessible, it was the holster was underneath his pants, all but the handle was visible. It nonetheless enabled him to retrieve it immediately when he was in danger. And if, especially given the tightness, he was wearing a tight suit. And again, we're talking about officers, the law protects officers who are off duty. So there's going to be a variety of, outfits worn of various tightness or looseness. He was wearing a tight fitting suit. Had he been holstering the pistol, behind him underneath his tight fitting sports jacket, it's unlikely he would have been able to retrieve it immediately to respond to what he actually and reasonably believed to be an imminent threat. So I think all of those things, and taking a step back, Congress was recognizing that it was dealing with trained law enforcement officers, and also wanted to relieve them of the burden of having to research the laws of 50 different states, or the law of every state in which they might be traveling. So if they're driving with their family across the country, they don't have to, research Pennsylvania law, then Ohio law, then West Virginia law, et cetera, et cetera. And so recognizing that there are variations in state laws, and that there are different methods of concealing weapons, in context, I think you have to say that Congress recognized a flexible definition. If it wanted a stricter definition, it could have defined concealed. The final point here, and I don't know that the court needs to reach this sort of broader question, given that what the trial court found was non-concealment was incidental to the self-defense in this case. But more broadly, if you look in context, and given the backdrop of state law against which Congress was legislating, in which 45 states at the time LEOSA was enacted permitted open carry, I think in context, the best reading of the statute is that Congress was protecting concealed carry in addition to open carry, not in lieu of open carry. And that's why it didn't define concealed. And that's why the committee reports on both sides recognize that officers would have the ability to use their service pistols.
Wait, is this is your argument? I'm sorry for interrupting, Mr. Lipper.
No problem.
This is your argument that what is really meant is that the officers can carry their revolver even if it's concealed?
Exactly.
And what is your best, I'm sorry, authority for that position?
I would say it's a couple of things. I think you start with the basic point, which the Supreme Court has made clear, that you look at, when you're interpreting a statute, you don't look at words in isolation, you look at the entire structure, the purpose. So I think you start with that. Then, and there's a number of cases we cite, both the healthcare case, King versus Burwell, in which the court, I think, pretty famously held that subsidies for state exchanges mean subsidies for state and federal exchanges, given that interpreting the law otherwise would undermine the law's purpose. And then a number of criminal cases, including Lagos, NE8s, and Bond, all of which, sort of either narrowed or otherwise altered what might be the threshold understanding of a word given the overall statutory purpose. But also, I think the canon that Congress legislates against the backdrop of state law. And given that states, 45 states at the time permitted open carry, and even states that prohibited open carry, or localities that prohibited open carry, like the district, acknowledged that concealed carry was more of a concern. It's impossible to believe that Congress would have protected concealed carry, but nonetheless held officers criminally liable for open carry. And that's why, and I want to be clear, if you look at the committee reports, both the House and the Senate committee reports, the proponents and the opponents of this law, they disagreed very strenuously about whether this law was a good idea, but they all agreed that this law would allow officers to use their service pistols. And the people who opposed the law opposed it primarily for that reason. They didn't want officers to be able to use their service pistols, but everyone was contemplating that there would not be constant, concealment, however you define it. And so,
what do you think the law prohibited? What do you think the law left? In other words, if you say that Congress, was operating under a background that allowed open carry, and you think it's hard to believe that Congress really meant to prohibit that, and they did use the word concealed carry in here, what do you think the statute actually, what do you think goes too far? It sounds like you're saying that the statute basically must be read to allow police officers to carry their firearms, concealed, partially concealed, unconcealed, throughout the country.
So let me say, I'll say two things. The first thing is the court does not need to go that far in order to rule for us in this case. I think even if you interpret the statute to prohibit, one of either open carry incidental to acknowledge self-defense, or if you understand that sort of concealment includes holstering a pistol with the handle visible, then I think you don't need to reach the broader question. I would say that even if
but we want to be consistent. We want to have some sort of standard that is clear. I mean, if I see somebody with a holster and there's a what looks like a gun handle sticking out of the holster, I know what's on the other end of that. I know what's inside the holster. It isn't a lollipop. And I think that it would be hard to say, what troubles me is it would be hard to say that, that's concealed or why partially concealed in such a circumstance would make a difference. Because anybody who looks at that person will know that person is carrying a gun, a handgun.
Well, so a couple of things. First of all, at the time Congress enacted LEOSA, in 45 states, anyone with law enforcement officer or otherwise would have been able to carry openly, the difference being license and registration. And if you see a person openly carrying a firearm, unless you go up to them and ask, you don't know whether or not they have a license or a registration. So I think the fact that you or me or other people might be startled to see, the handle of a holstered weapon, I don't know that that would have been Congress's concern, given the backdrop of state law in which it was
They
legislated.
did use the word concealed.
They did, but I think as the Supreme Court has had, it has to be placed in context. But again, I think I think if you look at what Congress had in mind here, even the trial court and even the government acknowledged that the firearm can be used for self-defense and the defense of others. I mean, that is not disputed, I think, by anyone. And so
the court did recognize that, Mr. Lipper, but the court also made a couple of comments to the effect that before Mr. Abed removed his gun from the holster in self-defense, he had, I think the court's language was flashed. He sort of flashed the gun a couple of times, implying that he was actively trying to show others that he had a gun. What do we make of that? Because it occurs to me that we could avoid the question of what exactly the statute means. It is odd that Congress used the word concealed if that's not what it meant, if it meant concealed or unconcealed, but we could avoid that if we thought that whatever else concealed means, it doesn't cover a situation where someone is, as the court found here, trying to show others he has a gun. What's your answer to that?
So I would say a couple of things. The first thing is that we are dealing, so first of all, we're dealing with and the video is in the record, and I believe the court has the video as well. And the video shows it's I think just, something like 1 minute and 6 seconds. So we're talking about a very short amount of time before the service pistol is lawfully unholstered. This is the first point I'd make. The second point is, if you look at the video, there is no, Mr. Abed's hands are in his pockets. At no point does he gesture to the weapon. There is a point within those 66 seconds in which he briefly unbuttons his sports jacket, but that actually does not affect the visibility of the holster. The holster was visible because his sports jacket was tight fitting and buttoned. And when he unbuttoned his sports jacket, we saw more of his shirt underneath, but we actually didn't see any more of the pistol. So I mean, I think to the extent I don't know exactly what he meant by flashing, but to the extent flashing is suggesting some, within that time period, some conspicuous gesture to or emphasis on the service pistol. I don't think the video, I think, pretty clearly refutes that. But again, I also think, and this is where I think, if Congress wanted trained police officers to be able to defend themselves and defend others, I think that there has to be some breathing space, right? Because otherwise, if an officer defends, if the officer admittedly, as in this case, ends up defending himself or defends other people, but knows that if they, either take out or just show part of their service pistol 30 seconds, 40 seconds, 60 seconds too soon, if that is deemed after the fact, now they become a convicted firearms felon, with all of that entails, plus possibly likely losing their job as a police officer, then those officers will be chilled from defending themselves or defending others. And I think, again, whether or not you think it was a good idea to authorize officers to defend themselves and others in other states, that is what Congress's clear purpose was. And I would think if someone was looking at this case and saw that despite validly defending himself and being acquitted of all of the more serious charges premised on his use of a firearm, he was nonetheless convicted of 3 firearms offenses, including a felony, because the handle of his holstered pistol was visible for just over a minute before he was protecting himself from imminent threat to his life. And because he had stored his pistol in a manner in which enabled him to retrieve it immediately when the threat arose, I would think, and I would think someone would look at that and say, I better, you know what, I'll just keep my service pistol in my trunk. And whether or not that's whether or not that we prefer that as a matter of public policy, that was certainly not what Congress was intending when it created the defense. So I think to rule as the trial court did here, I think, again, it's not only inconsistent with how many states and many training manuals and experts in the field would define concealed, but I think it would also chill the officers from acting consistent with the very purpose of the statute, which is to have their pistols available for the immediate defense of themselves and others.
Okay, we'll give you a few minutes in rebuttal as you requested. Let's hear from the government. Counsel.
May it please the court. Good morning, David Goodham for the United States. I'd like to first address at a more global level how we should look at this statute. As we've articulated in our brief, the Law Enforcement Officer Safety Act, its plain language used only the phrase concealed carry. Plain language obviously is a very strong indicator of Congress's intent. A couple other things that I would note in terms of statutory interpretive canons that I'd like to draw the court's attention to that I think resonate powerfully here when this court is trying to understand the scope of the statute. Number one, as the defendant's own case law, United States versus Bond indicates, when you are looking at a preemption statute, that is when federal law is preempting state law, it should be interpreted narrowly. And I would point the court's attention to Bond 572 US at 858. It has long been settled that courts must presume federal statutes do not preempt state law. Obviously, we have an express preemption here, but the scope of that preemption is what's being debated now, and this court should be very careful if it's expanding the scope of that preemption. The second global interpretive canon I'd like to draw the court's attention to also emanates from the defendant's own case law, Bond, and that is we are talking about federal law basically mucking around with state law. That is, Congress has said that despite numerous states' efforts to regulate open carry, Congress is said that at least with concealed carry, law enforcement officers get a pass. And if you look at Bond, and this is 572 US at 858, they rely on the, quote, well-established principle that it is incumbent upon the federal courts to be certain of Congress's intent before finding that federal law overrides the usual constitutional balance of federal and state powers. So we have to look at Leose with that backdrop in mind. There's a third canon here that I would suggest is specific to the district and its CPWL and UF and UA laws, and that comes from Thorne and Thorne itself. Thorne says that exemptions to the CPL statute must be narrowly circumscribed given the clear intent of Congress to strictly regulate guns in the district. And that's at 55, 8/3 at 878. So from the government's perspective, we have plain language that dominates here. Concealed carry, that's replete both in the legislative history. It's also replete in the statute itself. Number one. Number two, we have these three sort of, I would say, overarching interpretive canons that dictate this court must be very careful when it is taking up the yoke that my opponent has suggested is appropriate here and to expand this beyond concealed carry. The further point—
when you talk about expanding it beyond concealed carry, now I guess the federal government does not have a concealed carry law, right? And the district does not, but many states do. If this conduct, this video, this entire scenario had occurred in a state with a concealed carry law, do you think the courts of that state would uphold a conviction of the officer for concealed carry?
I'm sorry, it's my own fault. I'm having trouble following your question.
Well, I'm wondering if under state laws, your typical, I'm not saying there is a typical, but your typical state law prohibiting concealed carry, would Mr. Abed be guilty under those laws?
This was
in
not
the
concealed.
circumstances of this case?
No.
I have the impression that the laws, that there's some variation, and that in some states, his conviction would be upheld. In other states, maybe not, under a concealed carry law. You don't think that's true?
I don't. And again, I apologize if I'm misunderstanding your question. And I think this gets to my opponent's point that he raised several times in both oral argument he raised in his brief. He made the suggestion that many states, I believe was a phrase he used, would say that a partially visible gun in a holster is not concealed. He has cited only 5 cases that he suggests support that proposition. At note 21 of our brief, I think we have thoroughly dispensed with that suggestion, number one. Number two, he cites repeatedly, and he has here both and also in his brief, these training websites. I would highly encourage the court. I went to these sites in anticipation of this oral argument. I would encourage the court itself to go to these sites. And in particular, there's a site that that is labeled 9 ways to concealed carry, to conceal carry your firearm. That website, and again, this judge, you will be the judges if you go to this, but I do encourage the court to go to it. It illustrates the 9 ways that a concealed carry can be undertaken consistent with the law, with photographs. And in every one of those photographs, I would suggest, again, you will be the judges, obviously. Every one of those photographs, you will see the model either holding back a jacket or holding up a shirt, an oversized shirt, or holding up a skirt for a thigh holster, holding up a pant leg for an ankle holster, or the 9th way to conceal a weapon is to put it in a purse. And a photograph illustrates you conceal it entirely in a purse. My point being that as far as I look at the landscape that my opponent has presented here in terms of training manuals, websites, state law, I've found nothing that supports the suggestion that a partially visible gun in a holster with the handle showing 50%, I would suggest in the video we have here, equals a concealed weapon, which I would further suggest is entirely consonant with the plain language understanding of concealed, which is hidden from view or hidden from ordinary observation. No one could look at that videotape, over a 1.5 minute videotape, and demonstrating that that gun was hidden from view. It's plainly visible. I would also disagree with.
I'm sorry, can I interrupt with one question, Mr. Goodhand? So if he were wearing like a bigger jacket that as he was walking along, you really couldn't see the gun or the holster, and then everything after that point happened the way it did, you know, like maybe he unbuttoned his jacket in a way that showed the gun, would he be giving up his right to carry a concealed weapon in the district based on, you know, a couple of times where it isn't concealed under your definition?
I think that would be a much tougher scenario for the fact finder. And that's what this boils down to. You take the common sense, ordinary meaning of concealed, hidden from view, and you ask the fact finder to ascertain whether or not this was hidden from view. If you were to boil this down to an inadvertent, for example, flashing of the gun or something of that kin, I think that would be very difficult for a fact finder to conclude that that equaled concealed and violated the concealed, an open carry prohibition. So I think that boils down to the fact finding role. If you agree on the definition, then what does the fact finder determine? Here we have the fact finder determined that this was a not concealed weapon, plainly visible and supported by the video, I think, quite clearly. One other point about the video is I think even as the defendant approaches the 3 persons sitting on the steps, as my opponent has suggested, his suit jacket was buttoned. the gun is outside of his suit jacket. It's hard for me not to look at that video and come to conclusion that this was a deliberate act on his part to demonstrate that he was an armed individual as he approached those persons on the steps. So this notion that somehow we're going to have a chilling effect on law enforcement officers who are otherwise going about their business on vacation, for example, in a state that prohibits open carry, and then they engage in self-defense when they're attacked, I would suggest is entirely belied, at least by the record here.
On the question of statutory interpretation, how do you respond to appellant's argument that Congress could not have meant, given their concerns, Congress could not have meant to apply too strict a definition of concealment? They must have been willing to accept some play in the joints. They must have had in mind, a partial concealment would be basically enough as long as it's not too flagrant. There's a line drawing problem here that I pressed Mr. Lipper on, but I would also press you on this question of how consonant do we think it is with Congress's intent to be applying the law to the concealment definition so strictly?
I think it's entirely consonant. I think what Congress has done here is quite reasonable. There are states that have determined, based on their own state legislatures, their prerogative, police powers are traditionally reserved for the states. Many states have concluded that an open carry creates more danger than a concealed carry. And so they have regulated that quite strictly. In that context, what we have here is Congress saying we will not override those laws because I would suggest Congress implicitly agrees with the conclusions of those states that does heighten danger. We don't want to unleash hundreds of thousands of retired and active law enforcement officers to create volatile situations in those states that prohibit open carry. And instead, we will allow a free pass for concealed carry that doesn't create those myriad safety issues. And in the context of when an officer is actually endangered or others are endangered and he has to use his concealed weapon, there are self-defense availabilities for that narrow circumstance. And a couple of points on that before I cease my point. In our brief, we pointed out that Florida, for example, has written directly into its statute that the temporary revelation of a gun in the context of self-defense does not defeat, does not equal a violation. This court, and I apologize for not bringing this to your attention, but I just found it recently. This court has said the same thing in United States versus Mack, which is 6A3rd 1224. And that Mack says this jurisdiction has long recognized that one is not guilty of carrying an unlicensed gun during the period it is actually used in self-defense. And then my opponent in his reply brief cited to a New York case, People v. Williams, that he suggests would not recognize self-defense in that context. I think he's probably right. In New York, that's probably true. But if you look at the concurrence in Williams, and that's at page 163 NE 3rd at 475, the concurrence makes the point that New York is quite the outlier. New York's conclusion that the statute would not permit justification or necessity as defenses to criminal possession sets it apart from many states that do. And it cites a case that collects the cases from other states and federal circuits that, quote, allow self-defense or necessity as a defense to unlawful possession of a weapon, close quote. So yes, there might be a tiny fraction of instances where, for example, perhaps a zealous prosecutor decides to hold a police officer accountable in the context of a true self-defense situation. That seems hard to believe that that case would ever be brought, number one. Number two, I would suggest that the authorities we've cited demonstrate that prosecution would fail, even if it got off the ground.
This may be reading too much into the facts here, but suppose a situation in which an officer from another state is in town and, at 4 a.m. feels like, oh, I have to go into this dangerous neighborhood and I'm alone and I do have my gun, and makes the judgment, well, I'm going to have it displayed so that I'm not attacked. And for a few seconds, a minute, does that. And a court later says, that judgment was a bad judgment on your part. You were too sensitive to the possibility. You weren't really under attack yet. Close questions like that, and the officer gets a felony conviction.
Again, it seems to me that it would boil down to the fact finder's determination of whether or not we've met the definition of concealed. It strikes me that pursuant to the letter of the law, I would think that might be a violation. But again, I would suggest that's a very, very, very rare instance. And when considered with the plain language of the statute, coupled with the interpretive canons that indicate this court should narrowly interpret any exemption that mucks around with the state's police powers, coupled with Thorne's own recognition that CPLWL exemptions in this context should be narrowly interpreted. I think this court should be very careful about accepting my opponent's argument that now, essentially, I look at that video and I can't see the difference between that video and a uniformed officer walking down the street in this city on any given day. That's what's going on. And that's not what I don't think Congress meant when it said, we give the right to qualifying law enforcement officers for concealed carry, period.
So isn't that inconsistent with the court's findings? You probably know them better than I, but I thought the trial court was saying it was not concealed at, very discrete points, not what you're saying of him basically walking around with it not being concealed.
I don't think it is, and I would inconsistent that is with the court's finding, and I would direct this court's attention to the December 16th transcript, and the court says he's actually citing to the video. It's Exhibit 2B, and he says, and this is from 354-23, and there's the gun, and he's sort of almost pulling his jacket back to show Allison's friends that he was carrying a gun. I think what the court did was ground its findings in the video itself. And as this court can see for itself, that video demonstrates that at least for a minute and a half, that gun was plainly visible. That's a supported factual finding that this court should affirm.
And what do you think of where does the rule of lenity come into play with your list of interpretive canons?
The rule of lenity, as this court is certainly well aware, is sort of the last bastion to the extent that you go through all other interpretive canons before you get there. If after exhausting all interpretive canons, you get to a grievous ambiguity conclusion, that is, the statute is grievously ambiguous, the rule of lenity comes into play. Again, I would suggest the plain language governs here, coupled with the interpretive canons I cited, leads to the conclusion that the rule of lenity does not apply here. We don't have a grievous ambiguity. One final point I would make is, I've offered 3 definitions of concealed. My opponent has offered nothing to oppose those definitions. That's because there's agreement. Concealed means hidden from view. I believe I cited a federal case that gathers state authorities, and it says, quote, the classic definition of concealed is hidden from ordinary observation. There is no grievous ambiguity about the definition of concealed.
Mr. Goodhand, can I ask you a question on an entirely different point? and it relates to the UF and UA convictions. So it was in the defendant's testimony where he was asked whether or not he had a license to carry the weapon and whether it was registered in DC. There is this exchange in which the prosecutor says, but you don't have a license to carry a weapon in DC, right? Answer, no. And that gun isn't registered in DC, right? Answer, it's Prince George's County, my service weapon. Now, Mr. Lipper hasn't argued that these answers do not establish that he didn't have a license or registration, but it occurred to me reading them that one could say that the answer no to the first question is an answer to right. You don't have a license, right? No. Though we seem to read this as you don't have a license, no, I don't. Second point, that gun isn't registered in DC, right? Answer, it's Prince George's County. So he never says, no, it's not registered in DC. As I say, no one has raised this point, but my question to you is, how do we deal with that portion of the transcript? Do we defer to the trial judge's understanding of the testimony? Is that what we do? Because the trial court, upon reflection, did agree that the defendant had acknowledged in his own testimony that he didn't. Is that how we deal with that?
I would suggest the way you deal with it is this. I think there's a reason nobody has raised this to this point, and that is that the fair inference is that was, if you read it in context, that was an admission that this was not registered in DC. It was his service weapon from PG County. And then, of course, overlaying that is, if you're looking at sufficiency of the evidence is taken in the light most favorable to the government. So I would suggest that all of those as a backdrop lead to the conclusion that that was sufficient evidence demonstrating no registration and no license. And again, I would suggest that's why everyone seemed to understand that this was satisfactory for that element.
Thank you.
Counsel, thank you. Mr. Lipper, you reserved 4 minutes for rebuttal. We'll hear from you.
Thank you. I want to start saying I'm a bit surprised by Mr. Goodhand's suggestion that all of the training materials and all of the state's laws have this universal definition of 100% concealment. If you look, for instance, on page 46 of our brief, Lexipol, which is a company that trains law enforcement and public safety officers across the country. So an officer who was trained by them or who was just looking at their website would read, to be, quote, to be considered for concealed carry, a holster must completely cover the trigger while still allowing for a full firing grip on the draw. And the holster did fully cover, in Mr. Abed's case, the holster did fully cover the trigger. And then if
May I interrupt you on this point, though? I was a little surprised, actually, that the government encouraged us to look at this material. Am I correct that none of this material was introduced in the record in the trial court? By this material, I mean the manuals, the websites, articles about proper concealment.
That is correct, but I think because these materials, I think, go to Congress's intent and the way that the statute is interpreted. In other words, that Congress
were they submitted to? Did Congress consider them? Is that
I don't know that Congress considered these precise materials, but I think you can assume that Congress was aware of that Congress would have been aware in a statute regulating law enforcement officials, not lay people, but law enforcement officials would have been aware of the various definitions and uses of concealed. In other words, there's no reason to assume that Congress would have assumed that concealed meant 100% concealment when it's very clearly not the case, even in materials being used to train law enforcement officials. And, there's a photo on page 46 of our brief from that training agency that shows a weapon in a holster with the handle visible and is an example of a concealed weapon. I mean, the holster is entirely outside the person's pants, whereas, Mr. Abed's, the holster was primarily underneath his pants. So I think,
this gets to my question earlier, in which I think expressed some degree of puzzlement that anybody could say, seeing Wyatt Earp walk down the street with his pistol in his holster, would say he'd had a concealed gun.
Well, and this is where, again, I think, you and I might have that reaction. I'll, confess I'm not myself a firearms aficionado, but I think, again, we are dealing with a law, a law that is protecting law enforcement officials who have more specialized training and more specialized knowledge. And, in the same way that we might not, a layperson might understand state healthcare exchange to mean state and federal healthcare exchange. Ultimately, the Supreme Court said Congress unambiguously meant federal and state health exchange when it said state health exchange. And I think we're not talking just about training materials, but the interpretive canon that Congress legislates against the backdrop of state law. Not only did 45 states permit open carry, but states, just a quote from an Ohio decision that we cite in our brief, quote, "A weapon need not be totally hidden from observation in order to render it concealed within the meaning of the statute." Or from Arizona, quote, "One can carry a concealed weapon on one's person in a holster, scabbard, or case that is visible." Pennsylvania, the weapon was concealed even though a bulge on the defendant's hip appeared as an outline of a handgun. And so what Mr. Goodhand is saying is that notwithstanding these sort of various and more flexible definitions of concealed that an officer would be aware of, we are going to hold this officers subject to the strictest possible definition upon pain of felony criminal liability. And I think that is, that is hard to square, not only with sort of basic fairness and the rule of lenity, but also to Congress's express purpose here, which was to create breathing space for officers to not just, carry their guns, but use them in defense of others. I see my time has expired. I don't know if the court has any questions.
I have one question. Could you respond to Mr. Goodhand's, points about interpreting preemption statutes narrowly and so forth, and how that kind of plays in with your rule of lenity argument?
Sure. So I think if you look at it, obviously there's a number of different preemption cases in a number of different contexts. And then there's some cases in which it's clear from the statute that Congress intends to preempt quite broadly, either preempt the field or nonetheless preempt broadly. So Bond, the case that Mr. Goodhand cited, was a federal prosecution under the International Chemical Weapons Treaty for what was essentially a love triangle in which one of the participants tried to poison another participant. And in that context, I think the court quite reasonably said, okay, we are not going to interpret a chemical weapons treaty to sort of authorize what is actually a garden variety violation of state criminal law. And I think in that context, it made sense. But here, there is a very clear, Congress is very clearly intending to displace the law of 50 states plus the District of Columbia. And if you accept Mr. Goodhand's reading, even on the question of whether just the self-defense itself, I take Mr. Goodhand to say that, well, okay, if an officer is entering New York, they need to read these New York decisions to realize that, oh, if I use my service pistol in self-defense here, I can still be held liable for concealed carry. And while there is a concurrence saying it's unusual and maybe it won't be brought, that is the type of sort of legal analysis, 50 state legal analysis that Mr. Goodhand's interpretation of the statute would require, when what Congress was clearly doing here was creating a uniform playing field so that officers who are trained and who Congress trusted to use their firearms responsible would not have to sort of parse the individual firearms laws of every state. And the final point I'd like to make, and it sort of, I think, goes to what Mr. Goodhand's discussion of the trial court's findings is, I think one thing that's, I think, important to realize, if the trial court had believed that Mr. Abed was actually trying to threaten others with his firearm before he unholstered it, that would have served as a basis to convict him of the charges on which he was acquitted. The assault charges, those can be satisfied with a threat, and the self-defense, if you're the instigator, obviously the self-defense is much harder to show, and you have to show that you've, essentially sort of, there's some sort of circuit breaker. And so the fact that, I think what ultimately, I don't think it is while the handle was visible, I think if you look at the verdict as a whole, and if you look at the self-defense verdict, it does not support the suggestion that Mr. Abed was sort of threatening people with his gun beforehand, and upholding this conviction would require the court to interpret statute to draw this very bright line between the act of self-defense and the sort of minute or so leading up to it, even when the position of the service pistol leading up to it is what enabled Mr. Abed to use it immediately. What enabled him to defend himself was the fact that he was carrying his pistol in a common concealed carry position that made his pistol readily available. That is what enabled him to act in lawful self-defense. And that is also what entitles him to prevail under the Leosa defense.
Counsel, thank you both very much. The case is now submitted and you may log off.
Thank you.
We'll call the second case, SHAWKI Group versus EKHO Events. We're waiting for Mr. Rand, counsel for SHAWKI Group.
Yes, Judge, he was here, he just logged back out. I'm gonna check on him.
Thank you. Counsel, good morning. We've called the case of SHAWKI Group versus EKHO Events. Mr. Rand, you may proceed.
Good morning, Your Honor. I would like to please reserve 5 minutes for rebuttal. May it please the court, on behalf of Green Rock, I would like to start with the standard of review. Because this was a motion granted on the papers, the review of this court is a de novo review of the decision of the lower court. The key argument that we're making here is what's referred to in the case precedent as the lulling doctrine. And it follows a pattern I've seen in other contexts where a court will establish a principle in the law, and then the case law that follows the establishment of that principle establishes the parameters of the original principle. And so the first case says, hey, we have this lulling doctrine, and then after that you see various litigants try to fit their cases into the doctrine, and a lot of the precedent says, well, this case does not fit the lulling principle or the original principle in establishing parameters and boundaries.
So, Mr. Rand, what is in light of that? What is the best case you have that's closest to the facts of your case?
Well, I think the Daniels versus Pepco case and the East versus Graphic Arts cases are the best cases. And in the East versus Graphic Arts case, the court states at Atlantic 157 note 10, the example of the William J. Davis case where an employer manipulated hours to keep the pay the same to hide from the employee that he wasn't being paid the new minimum wage by statute. And that is a very small affirmative act. And what these cases on the lulling doctrine say is one has to have an affirmative act. It can't just be inaction by the defendant to trigger the lulling doctrine, and that the lulling has to begin before the statute has run. It can't start after the statute has run, and it has to span that time period. And in this case, the complaint and the record shows that in December 2014, the plaintiff signed stock agreements. And in January 2015, EKHO paid the first installment on monies that were to be transferred. The stock agreement said that EKHO would pay a sum of I believe, $230,000 over time and grant 10% interest in the company. And the last payment on those installments took place in October 2016. So that's one part of it, and it's part performance. In October 2015, EKHO requested a modification that SHAWKI's 10% interest would be finalized after SHAWKI did some bathroom construction. And that is an email that was an exhibit to the complaint, and it is at Appendix 38. In November 2015, SHAWKI submitted plans for these additional bathroom construction. In December 2017, EKHO notified SHAWKI to begin work on this construction. On February 2018, EKHO was told to cease the work. In January 2019, EKHO again says, start the work, and then it says to stop the work again. And as late as February 2020, just a few months before we file suit, EKHO says to SHAWKI, you're going to be able to start that work soon that will allow you to finalize this deal and finalize your receipt of the 10% interest.
But why didn't he, why didn't SHAWKI know at the time what you are referring to as a modification was sought? Wouldn't SHAWKI have known, hey, we had this deal and I haven't received a substantial part of it? What's the relevance of that moment? You're portraying it, I guess, as the equivalent of we know, just hold on and do a little bit more work and then we'll get you what we already owe you. Is that a fair characterization of what happened?
That certainly could be interpreted that way. But I think at that point, SHAWKI is presented with a choice. It could have treated that as a breach, and it could have taken the position that, no, I don't have to do this. You owe me the 10% now, and I insist on that. But SHAWKI chose not to do that. It responded, and beginning in 2015 and all the way through 2020, that's fine. I'll do that work, and we can do it that way. In these circumstances, it certainly amounts to an affirmative act, a concrete affirmative act, which is the way the case law of the district expresses this, to lull SHAWKI into not pursuing a lawsuit. And certainly SHAWKI's decision to proceed in that manner is something that's favored by public policy. The public policy of the District of Columbia is that voluntary resolution of civil controversies is in high judicial favor. That's from the District of Columbia Court of Appeals case of Moore versus Jones, which follows the federal case of Altera versus Robinson. So SHAWKI should not be penalized because it chose to accede to this requested modification. And also the
What was the controversy? Why, in other words, what was the rationale for asking SHAWKI to wait to receive the necessary signed documents?
Well, I think the rationale was the way it was presented to SHAWKI, I believe, was that if you will complete this additional work and do these bathrooms, then we'll finalize the transaction.
And why doesn't SHAWKI say, wait a minute, we have a deal that if I did what I have already done, we will finalize. And in fact, the deal was even better than that. He didn't even have to finish doing what he, but why didn't he say, what does one thing got to do with the other?
Well, I think SHAWKI could have taken that position, but it chose not to. It was, I think.
Well, I asked you because you said this was sort of a resolution of a controversy. And I'm wondering, were they disagreeing about something?
Well, I'm just pointing to the public policy principle that voluntary resolution of civil controversies is favored, and SHAWKI chose to treat it. SHAWKI was presented with a choice: you can agree to do this or not, and it chose.
Well, he had another option. He could have said, "Why are you asking me this? Why don't you just give me the documents to which I'm entitled?" Well,
I suppose so. I mean, that might be considered a form of disagreeing with it and standing upon its rights, or a step to do that. But what the facts pled in the complaint show is that SHAWKI did not do that. The SHAWKI immediately agreed. That's fine. We'll do this. And in a month after the initial request in October 2015, SHAWKI submits the plans to EKHO for here's the additional bathrooms that you want to proceed with our transaction. And it
no further question. When Mr. SHAWKI did that, was it clear that he was not charging that for that work on the bathrooms, he was going to price it the same way he priced the original work, namely he would forego building in a profit and building in, I think, overhead, and give them a basically at cost job, because the way he was going to profit on this deal was the eventual interest that he expected to get in the business. Was that clear? In other words, I view my understanding of the original $230,000 transaction was that in exchange for the 10% interest in the business, I'm simplifying this slightly, but you get my point. In exchange for the 10% interest of the business, SHAWKI was going to give them a very favorable price. He was just going to give them the work at cost, do the work at cost. And was it clear that aspect of the deal was continuing when he agreed to do the bathroom work?
I don't think so. As I read the key email, the Exhibit E to the complaint, which is at Appendix 38, it's what that agreement was a little different. That was that it was going to be a fixed price deal. So SHAWKI, which the principal of SHAWKI is Tamer El-Shaki. Mr. El-Shaki receives this email, and what it says is that this is from Mr. DeMoya on behalf of EKHO. You will design, build, supply, and install mezzanine bathrooms at EKHO stage for a total cost of $24,000. So I think that was a fixed price deal, not whatever the costs turn out to be and you without profit and overhead. But in this case, you'll do it for a flat sum of 24,000, whatever it takes.
Okay. And it says in that email that that you've given us a time frame of 6 weeks to finish the bathrooms. In the event, if I understand correctly, it took like 4 years or more.
Correct.
Why is it that, now I realize that EKHO at various points called the halt, said we have cash flow problems, whatever. Why did it take 4 years? I'm not even sure the bathrooms were ever finished, to be perfectly honest, but at least 4 years.
Well, because the fits and starts in SHAWKI group being able to do this were caused by EKHO. I mean, you can't do the work without access. And in EKHO, I think, and it's fairly, I believe it's pled in some detail in the complaint at appendix 13 and 14, 13 through 14, the various paragraphs of the complaint, that EKHO is saying we don't have the $24,000 that had been agreed to be paid in this email, or we have the place is closed for various reasons, but the fits and starts are all laid at the door of EKHO. I mean, SHAWKI was ready, willing, and able throughout this period, and in as late as a couple weeks before the EKHO group was sold out from under SHAWKI, the EKHO's representative is saying you're going to be able to begin or resume the work on these bathrooms soon. And in fact, it was never done because
At that time, when that was said, was there any reference to the to finalizing the 10% stake? As alleged in the complaint. I mean, we're limited to the four corners of the complaint, essentially, for
right.
purposes.
No, I don't believe so. It wasn't stated that Angel still get the 10%. It was simply that we should have our issues resolved. This is at paragraph 31 of appendix 14. We should have our issues resolved by next week, and you can resume your work on these restrooms very soon.
And Dan, do I understand that as far as the complaint indicates, the last mention between the parties of the what I'm calling the 10% stake was in this October 29th email, October 29, 2015 email?
I believe so, at least as the complaint states it. But once that 2015 exchange occurs, that will finalize your 10% after you finish the restrooms, then the rest of the course of time, when they talk about finishing the restrooms, that relates back to that original conversation. They never renounced it. And there is, that brings me to the other ground for this, if we don't look at the lulling doctrine, it's a very basic principle of statute of limitations law is known as acknowledgement of the debt. And it's a well-settled basic exception to statute of limitations. And in the case law on acknowledgement of a debt is that unless the defendant affirmatively says, look, I'm not going to pay you, then the plaintiff is justified in waiting. And
you raised the acknowledgement of the debt argument to the trial court in the argument on the motion to dismiss?
I believe that was in there. Perhaps while I wait for my rebuttal time, I can find that particular point.
Now, do I understand correctly that the last time we have an explicit acknowledgement of the debt was October 29th, 2015?
That's when the lulling pattern started.
But now I'm focusing on what you've just read.
Okay, Dave.
Of the debt.
Yes, I think that's well, I don't know. I don't think so. I mean, the acknowledgement, once you tie the 10, we'll finalize your 10% to finishing the bathrooms, then it's all of the wait, and we'll get to this soon, and you can do the bathrooms next week. All of that stuff is combined with the acknowledgement of the debt. So every time they repeat, you know, here's the carrot, you're almost there, that renews the acknowledgement of the debt, because it goes back to the original postulation that they presented to SHAWKI, which is if you will do this, then we will finalize your 10%, which it could have rejected that, but it chose not to. Its position was fine. That's a little thing. We'll do that.
You've reserved a few minutes for rebuttal. Let us hear from counsel for appellees. Mr. Spaeth?
You're on mute.
Mr. Spaeth, you're on mute. You'll have to unmute yourself.
My apologies to the court. These Zoom hearings are still trying to figure my way through them.
We all do it.
Thank you again, and may it please the court. I'd like to just briefly, or start by very briefly reviewing the legal standard that's applicable here. As noted in the Camero versus District of Columbia Rental Housing Commission case, 891 Atlantic 2nd at 258, and as affirmed in other cases, this court has held that the lulling or unique circumstances doctrine was designed to create a very narrow, equitable exception to vigorous filing requirements. And what that means, as also noted in the Camero opinion, is that there must be concrete evidence that clearly establishes that the defendant did something to affirmatively induce the plaintiff to sit on its rights. And this complaint simply does not satisfy what I would characterize as a very exacting standard. The appellant argues that it was lulled into believing that my client would honor its promise under the share transfer agreement to deliver 10% of its shares. The problem is that the email on which this argument is constructed does not actually speak to the promise under the share transfer agreement that is the subject of appellant's lulling claim. Rather, on its face, the email is referring to some proposed agreement or understanding that by its terms has not been drafted, much less entered into. If you
Wait, are you saying it's talking about a different 10%, or you're making a more specific argument than that?
I'm making a more specific argument. If you look at the language of the email, it says that upon completion of the bathroom construction, you will receive documentation regarding shares in the business to be drafted and agreed upon by the parties. This is clearly referring to a potential future state agreement, not to an existing obligation. The documentation relating to the shares had been drafted and provided to the appellant nearly a year earlier, reflecting what appellant alleges in the complaint was a valid and enforceable agreement that obligated my client to transfer 10% of its shares. So if this email was referring to that particular existing promise, there'd be no reason to discuss drafting and agreeing upon documentation relative to the transfer of shares because that had already been done.
Well, couldn't it be both? Like, couldn't it be referring to the previous agreement and just, I don't know what, referring to updated documents that will actually bring it to fruition, what didn't happen before?
I mean, certainly, Your Honor, there's a lot one could read into this email, and I'll have another point to make on that in a minute or two. But at this point in time, we're on the appeal from the granting of a motion to dismiss. And this court is required to, assess the allegations of the complaint, the documents that have been provided in the complaint, and determine whether, as a matter of law, those meet the standards. So trying to determine what could have been meant, what could have been interpreted, what someone, could read into the email. I'm not sure that's really necessarily.
Well, then is your point that this is really a brand new agreement that was then breached?
I think that's yes. I think that is not breached because it was never entered into, and there was no allegation that it was ever entered into. So, but yes, I'm alleging that it's on its face, it's referring to a new and different understanding. And certainly, if I'm the appellant and I have an agreement in hand with documentation in hand, drafted from a year earlier that says I'm entitled to 10%, and I get this email, this email is not going to, lull me into sleeping on my rights. It's going to cause a 3-alarm fire. I'm going to call, or I'm going to write back, and I'm going to say, why are you talking about drafting and agreeing documentation to transfer shares when not only have you promised me the shares, but the documentation for that, which I signed a year ago, already exists? There's no allegation to that effect in the complaint.
Well, he could have understood it as the signed editions of those earlier documents, which still has not yet occurred. What other documentation could this have been referring to?
It could have been referring to a new agreement. It could have been referring, and I believe it's.
Is there any evidence that there was a new agreement? Is there any allegation in the complaint that there was any sort of new agreement other than the other, relating to the 10%? There's obviously a new agreement for the bathrooms. Maybe, and even if it's referring to a new agreement, that may still may have a lulling quality to it.
Your Honor, with all due respect, you can't sue for breach of contract unless, of course, there's a contract. So you can't be lulled into foregoing your right to sue for breach of contract for a contract that doesn't yet exist.
Oh, well, I understand that, but the question is whether this email and whatever circumstances we have surrounding it operated to lull, or whether a trier of fact could find that it operated to lull appellant into not asserting his contractual rights, the contractual rights under the 2014 agreement. And it seems to me that a fair interpretation is that it did. He, for whatever reason, EKHO wanted him to hold off getting on the consummation of his 10% stake until this bathroom work was done. He's thinking to himself, I have a nice relationship here with these people that we're trying to establish. Okay, I'll go along with that. And as it happens, he doesn't realize it's going to take 4 years, but he's lulled, you could say, into not asserting his rights, because there is that promise out there, as it were, of if I get this bathroom work done, we'll get it all done, and everything will be fine. I'm not sure I understand why that's not lulling, why that doesn't fit the definition of lulling.
Well, I respectfully disagree in part, well, for several reasons, Your Honor. First, there's nothing in the email that talks about holding off. And the language of the email that talks about drafting documentation to be agreed upon is flatly inconsistent with plaintiff's claim that there's an earlier agreement already in place. And I think it's also significant in this regard, not only to focus on what the complaint says, but also what's not, or what the email says, but also what's not in the email. The email does not ask appellant anywhere to delay bringing a claim for breach of an agreement. Doesn't even mention the original agreement. The email does not say do more work and we'll give you the shares we promised you a year ago. The email nowhere, expressly acknowledges that any shares are owed to begin with.
Is that kind of specificity required, or is it reasonable to say those things are implicit?
Well, I don't know that the specificity is required, Your Honor, but when you are applying the standard that this court has laid out for a lulling claim, which talks about concrete evidence that clearly establishes affirmative inducement, I think for the various reasons that I've just mentioned, this does not cut it. Now, the appellant has stated that this email kicked off I think in its brief, it called it a course of lulling activity. But as I think the court has noted here today, the next affirmative communication by my client post the October 19, 2015 email is not alleged to have taken place until December 2017, 2 years later. And none of the additional alleged activity, that is to say the activity following the October 29, 2015 email, is alleged to have mentioned transfer of shares, the documentation associated with the shares, much less acknowledge any obligation on the part of my client. I think it's.
But we're positing for the sake of this, exploring this idea, that a condition precedent, as it were, for raising your hand and saying, okay, let's get that documentation done, has not yet taken place because the bathroom work had not yet been completed.
Okay, but what you're really talking about there, Your Honor, and this is an argument, by the way, that the appellant has made a number of times in their brief, is that the agreement had not yet been finalized. Finalized in quotes being the word that they've used, and in fact, in the appellant's original brief, I believe it's at page 15, they say that the email evidenced an intent to finalize the transaction later. But again, as I think I mentioned to Your Honor earlier, I don't see how that helps appellant either, because by definition, as I said, a party can't be lulled into foregoing a claim for breach of contract if in the first instance, no contract actually exists. And so what an appellant is essentially arguing or advocating for is that it was lulled into inaction for a cause of action for breach of an expected contract. And I don't.
Well, I think everybody, he may have put it in a way that I would not necessarily put it, I suppose, but I read this and I think what they're talking about, I can't imagine what else they're talking about, is finalizing what they've agreed to, which is the exchange of the properly fully signed document conveying a 10% share. This recognizes we have documentation, whatever it is, regarding your shares in the business that has to be, this says drafted and agreed to by both parties. And you will receive that document when the bathroom work is done. I feel like your argument would be more persuasive if I could see some other documentation that this could be referring to. The context just seems to be, we know that the documents have not yet been signed, so there's still some preparation that needs to be done, even if it's only putting your signature on the documents and conveying them. And no obvious other interpretation of that language seems to present itself.
Well, Your Honor, the email doesn't say do the bathroom work and we will finally, after a year of waiting, and thank you for your patience.
Upon completion.
We'll now sign.
It doesn't. It assumes it's going to be done in 6 weeks. That's what I asked Mr.
Right, but it doesn't say what it doesn't say. What it doesn't say is that we'll just sign what was on the table before. It says there will have to be documentation to be drafted and agreed upon.
You could imagine that there might be other supplemental debt. I mean, this is a complicated stock transaction, if I understand correctly. You can imagine that there might be other documents that will need to be prepared in order to effectuate this, but I don't know that even if that's true, that necessarily detracts from its lulling quality.
Well,
That's what I'm
Mr.
sort of thinking
Spade,
about.
what would be your argument if you assume for the sake of argument that this email affected a lulling or was a lulling? What's your argument as to why, nevertheless, the complaint filed in, was it May of 2020 or whatever the date was in 2020, why that was too late? Because as you know, our case law says there may be lulling, but the statutory limitations period picks up again, starts to run again, if the action or event that has effectuated a lulling kind of expires and there's no more lulling. What's your argument about there being nothing in that interim between 2015 and the relevant date in 2017 that lulled SHAWKI?
It's twofold, Your Honor. Number one, as we discussed a little bit earlier, the next quote unquote affirmative action on the part of my client is not alleged to have occurred until nearly 2 years later. And secondly, neither that action nor any of the other subsequent actions that appellant has said make up this course of lulling speak at all in any way, shape, or form to an obligation to transfer shares, to a share transfer agreement, or to the documentation relating to that. So I don't see a course of lulling. If the court is going to say that that one particular email caused a lulling, there was still plenty of time within the limitations period for the appellant to have filed its claim. And again, as I said earlier, if I'm the appellant and I get the October email, I'm not reacting the way that appellant is saying it was appropriate and reasonable for it to do. And I'm certainly not waiting 2 years following that email to follow up on the status of the shares that I was promised back in December of 2014. So that's my response, Your Honor.
Thank you.
I believe I'm out of time. So thank you very much. I appreciate your attention and consideration.
Counsel, thank you. Mr. Rand, we'll give you a few minutes. And remember that you're on mute.
Thank you, Your Honor. With respect to the acknowledgement of debt issue being raised in the opposition to the motion to dismiss, I don't believe it was directly raised. I did not cite the Tiger case, and I used the word acknowledged in terms of acknowledging that the documentation of the shares was pending. That's an app 80. But I think that is separate from the lulling issue. And I think at least the evidence that was pled and with the standard of review and for the inferences to be drawn in SHAWKI's favor, this was a factual issue that the court below should not have tried to resolve on the papers. We're entitled to an evidentiary hearing, and whether there was an agreement in place because of part performance and because of acceptance by estoppel, or whether it was a pending agreement, is something that could not be resolved on the papers and had to be resolved by the trier of fact under the case law, and that case law was set forth in our opposition to the motion to dismiss.
Well, you did. I saw you did distinguish the cases that they relied on, but did you actually provide affirmative authority for this? I know you said those were administrative cases, so they didn't apply, but did you rely on your own case law?
In terms of the
requirement for an evidentiary hearing because of the fact-based nature of this question.
yes, at Appendix 82, the opposition stated that the question of when the statute accrues is a question of fact for the fact finder, particularly in terms of the discovery rule and inquiry notice. That's the way it was stated there, and I think the court. I'm not sure a party can just agree that, Your Honor, despite what the law says, we agree you can resolve facts on the papers. Certainly, SHAWKI did not express anything of that nature in its opposition, and it's just that it's something that the court cannot do. It can't grant itself that authority, and so. You know, it's a contradiction in EKHO's position that, you know, there was no agreement, but yet they rely on the terms of the agreement to say that SHAWKI should have done this or that. I see my time has expired. Thank you very much.
Counsel, thank you both. The case is now submitted and the two of you may log off. We'll call the third case on the calendar, RITA GDULA versus DC Commission on Human Rights. I think we're waiting for Ms. Hodge.
That's correct, Judge. Audio is trying to connect.
We don't see her either visually.
Okay, it's up now.
There we go. Okay, we have called the case of GDULA versus Commission on Human Rights. Counsel, you may proceed.
Thank you, Your Honor. May it please the court. Angelica Hodge for petitioner RITA GDULA. Before I begin my argument, I would like to reserve 3 minutes for rebuttal.
Thank you.
Thank you. Under the guise of a reduction in force in 2015, the Catholic University of America unlawfully terminated Ms. GDULA because of her age. As part of that reduction in force, Catholic University fired the 3 oldest administrative staff members, whose ages were 57, 65, and 77, in Marist Hall, while keeping the 5 younger employees, whose ages were 22, 23, 34, 37, and 39. Marist Hall housed Ms. GDULA's department and other departments overseen by the decision maker at issue here, that is, Acting Dean Bornholt. Despite that evidence, the commission granted summary judgment on Ms. GDULA's age discrimination claim. That was error. This court should reverse the commission's grant of summary judgment for 3 primary reasons. First, the commission incorrectly ruled there were no disputed material facts as to whether Ms. GDULA established a prima facie case of age discrimination. Second, the commission incorrectly ruled that there were no disputed material facts on whether Catholic University's alleged reason for terminating Ms. GDULA was pretext for age discrimination. Third, there were
May I
procedural flaws.
interrupt you about something? There's a little something I'm unclear of as a procedural matter. When you say that it was error to conclude that Ms. GDULA had not established the prima facie case and pretext, my impression is that Ms. GDULA did not try to establish anything. That when the motion for summary judgment was filed, she herself did not respond to it. And whatever record had been created, it's not at all clear to me that she had any participation in creating it, although maybe she did. I may be unaware of that. I'm familiar with the record that was created leading up to the probable cause determination by the Office of Human Rights. And I do want to ask about that. But what exactly did Ms. GDULA and her counsel contribute in the way of evidence for the court for the ALJ and the commission to consider?
Your Honor, a couple of responses to that. You're right. There was a record that was developed for the letter of determination. And then once the case was transferred over to the commission, the letter of determination was also transferred over.
Was any additional evidence elicited and put into the record?
Additional evidence was elicited, and what the evidence that I'm referring to when I refer to the disputed material facts here, rely on that letter of determination, which was transferred over to the commission, and then the numerous exhibits that were attached to Catholic University's motion for summary judgment. And in those, they contain a number of witness statements, which if the ALJ had complied with its obligation, which under this court's decision in Travelers Indemnity Company of Illinois, required it to consider the entirety of the record, which included those exhibits. Those exhibits show, in addition to the letter of determination, that there were disputed material facts here that precluded summary judgment.
I should not have forgotten to mention those exhibits, but so you are relying on essentially the record created and supporting the letter of determination, and your opponents at Catholic University's evidence presented with this motion for summary judgment to argue that the commission erred and the ALJ erred in granting summary judgment. Do I have that right?
That is correct, Your Honor.
Okay. So you're at a disadvantage a little bit by not Ms. GDULA not having participated in that motion.
Yes, Your Honor.
And that gets us to one of your other arguments.
That is correct, Your Honor. That highlights the prejudice and the harm that Ms. GDULA suffered because of the procedural errors here, which included the failure of the Office of Human Rights to provide counsel as mandated in Section 408.4 of the DC Municipal Regulations.
I'd like to focus with you on that a little bit, if I may. Do you think that regulation, and let's assume for the sake of our discussion that I interpreted exactly the way you do. Do you think that regulation is consistent with the statute? I'm thinking of the statute specifically that says that the commission shall represent the complaint. See, what I think the statute envisions, frankly, is a process similar to, you could say, there are differences, one where, the government prosecutes a case and the complainant is a witness. Now here, the complainant can also be a participant as a party, but let's put that aside. I think the statute is envisioning a typical case in which the complainant comes in, here's my evidence, and the commission, if it thinks, yeah, you've got something here, the commission prosecutes it. But the commission is not representing necessarily the complainant, which would be very odd because then the commission's attorney would have a conflict of interest potentially between the wishes of the complainant and the wishes of the commission. So I'm wondering whether the regulation interpreted as you do and I will tell you, as I am inclined to do, is a valid regulation. And this inconsistency was raised by Catholic University at one, as you know, at one point in the proceeding.
Yes, Your Honor. It was raised, but when the commission interpreted the regulation here to only require OHR to represent the complaint and not the complainant, or not the case in support of the complainant, they did not do so on the basis of there being some sort of inconsistency between the statute and the regulation, which I understand and I recognize the tension that Your Honor just highlighted, but they did not raise that. They simply interpreted the regulation as only requiring OHR to support the case in support of the complainant. And that is what they did here, and that was the error. And that is in part, what my
thinking was when I put this question to you was along the following lines. If the regulation is valid, and if it means what you say, then I think you may well have a substantial ground for relief, which we can get to. But if the regulation is invalid, then the ALJ essentially interpreted it correctly, you could say, or interpreted the law correctly, and you have no beef from the commission, from the office's failure to represent Ms. GDULA. Do you see what I'm getting at? And that's why I'm focusing on whether this is a valid regulation. Do you think it was the regulation is ambiguous, or do you think it's clear?
I think the regulation is clear, Your Honor. And on the face of the regulation, it says that the commission had to, if designated as such, which Ms. GDULA requested multiple times for representation from OHR, it says that the OHR
I'm not so clear on that, by the way. You may have to explain that statement to me, because I'm not aware that she really requested it multiple times. Let's put it that way. But before we get to that, tell me what you see. I'm thinking along the following lines. If she's right that she was entitled to representation, then she was misled by the ALJ. She's a pro se litigant, and that gets us to the question of, all right, what's the remedy at this point, which what we should talk about. But if the regulation's invalid, then this argument collapses, I think, and so that's why I was focusing you on it.
Yes, Your Honor. Our argument is that the regulation, at least as written at the time, it has now since changed, as Your Honor is aware. They've had an emergency ruling.
They made it. Did they actually have changed it officially now? I thought it was in progress. All right. Okay. I may have missed
it is. Apologies, Your Honor. The commission did say that it could be amended or modified, but they did an emergency rulemaking to clarify that because of confusion with the regulation, they changed it.
You know, by the way, this regulation has been on the book since a while. I forget what year it was, but it's a long time. This is the first time this issue has arisen, to your knowledge?
Yes, Your Honor. This is the first time that we are seeing the specific argument raised. I was surprised by that, but yes. And just, Your Honor, to go to a question that you raised, or a comment that you raised before about Ms. GDULA, did she actually request representation from OHR before multiple times in the record? I actually have a few cites to the record that I would like to refer you to. On page 317 of the joint appendix, that's the very last request that Ms. GDULA made for representation from OHR. That's one that the commission highlights in its briefing. But there were two prior requests as well. So if you go to page 321 of the joint appendix, when Ms. GDULA, at varying points in time in the proceedings below, she was represented by private counsel, but because of the call, she was unable to maintain private counsel through the entirety of the proceedings. And so when her second set of private counsel withdrew, that withdrawal included a request from Ms. GDULA that she have representation from OHR. And then in addition, Ms. GDULA—
discussion. Right, okay.
Yes, Your Honor. And then there is actually one additional request that she made below, and that was in a motion to stay discovery deadlines. That's also on page 321 of the joint appendix. And in that, she mentions that she would request approval, she would request representation from OHR. And in fact, in response to one of those, that's where the ALJ below said, and I quote here, despite the language contained in DC municipal regulations, Title IV, Section 408.4, Attorney Byney, that is the representative from OHR that entered the case proceedings below, will not represent the complainant personally. And so the commission, the ALJ addressed this issue below, is our argument. Unless Your Honor or anyone else has any questions.
What's the remedy at this point?
Procedural.
So suppose we agree with you. Suppose we agree that there was an error, specifically, suppose we agree that there was an error here. She was misadvised by the ALJ. She was entitled to have under the regulation, then in effect, she was entitled to have the Office of Human Rights represent her interests in this action. And she has not forfeited or waived that right by any sort of untimeliness or anything else. As a result, she was prejudiced because she did not have anyone marshaling the evidence of discrimination at the summary judgment stage on her behalf. What's the remedy at this point, in your view?
Your Honor, the remedy would be for this court to vacate the commission.
We vacate the commission. We vacate the grant of the order of summary judgment. And what's going to happen on remand?
On remand, the case will need to be the evidentiary hearing. The proceedings will need to be reopened. So it would be vacated.
Who would represent
the Office of Human Rights? The Office of Human Rights should be required to represent her under Section 408.4.
Even though the regulation no longer requires it?
The regulation permits this is assuming that the regulation has not changed again. So I'll add that caveat here, Your Honor. But under the emergency rulemaking that they made, yes, the OHR would represent the public interest, but as long as the complainant's interests align with Ms. GDULA's, if Ms. GDULA's interests are aligned with the public interest, they could also provide her representation with that as well. But in addition, Ms. GDULA would now know that would now have a clear understanding from this court of what the contours of 408.4 require, or I guess under the new rule is 408.1. She would at least have an opportunity to obtain pro bono counsel or some other counsel to represent her below. But that would be
what puzzles me about that, I guess, and maybe I haven't thought this through well, so I want your help on it. That seems to put her in the position, to just put her in the same position she was in, the first time this was before the commission. So I don't know if the only relief, you see, I'm thinking that the commission, the Office of Human Rights would presumably say, look, our interests diverge. Our interest was in the settlement we reached with Catholic University. That's why we then left the case. We're not interested in pressing your, rightly or wrongly, we're not interested in pressing your interest. So if on remand, they don't have to, under the current regulation, represent her, and indeed it would be an odd representation. How could you have confidence in your counsel if your counsel has, different interests, is loyal to a different position? It seems like sending it back would have a quality of a nullity, because it would just say, do over what you just did the first time.
Well, Your Honor, there would be a distinction this time as for the first time. When in the proceedings below, each time Ms. GDULA requested representation from OHR, it was at least her understanding that they were going to be representing her interests. The distinction, the argument that we're having,
they withdrew, but they withdrew. Yeah, I thought the office withdrew after they settled with the university. Am I wrong about that?
They did withdraw, but for at least two of her requests for counsel, OHR had at least one OHR had not yet entered the case, and actually for three of her requests, OHR had not yet entered the case. For the last request that she made for counsel, that was after OHR had withdrawn. And so her continued requests show that there was some confusion over what 408.4 actually required. She, reading the plain face of the statute, believed the argument that we are raising now, the interpretation that we're raising now, and that is that OHR was supposed to have represented her interests. Going back, if this court were to remand the case now, there would be a clear and provide guidance to the agency and to Ms. GDULA on what the contours of the requirements are under Section 408.4. That would provide her with clarity as to what are her rights under and what are the obligations of OHR under 408.4, because the record shows there was clear confusion on that point. And that would allow her to at least develop her case with that in mind. And Your Honor, I see that I am
I'm going to give you a few more minutes because I took up so much of your time that I think fairness requires you to get a word in too on what you want to talk about. So if there's another matter that you want to address, take another few minutes.
Thank you, Your Honor. In addition to the procedural issue that we just discussed, which is an independent basis for vacating the decision below, this court also has an independent basis on the merits for vacating the decision below. And that is because of the commission erred when it granted the summary judgment on Ms. GDULA's age discrimination claim. Now, this court uses the McDonnell-Douglas test when assessing cases like this, and there are only two of those elements that are at issue for this court. And that is Ms. GDULA's qualification for the position at issue, which was an administrative pool, and then the second issue being an inference of discrimination. In the interest of time, I won't go through all of the evidence. I'll refer the court to my briefing on that point, but I will just briefly highlight a few of the key facts. As for whether Ms. GDULA was qualified to work in the administrative pool, the evidence shows that Ms. GDULA's supervisor testified that she was qualified for that administrative pool. At this stage of the proceedings, summary judgment, that alone was sufficient to raise a genuine issue of material fact, and that is all that she was required to do at this stage of the proceedings. I'll proceed to the next issue, which is the inference of discrimination. And so here, the university, the decision maker at issue here, Acting Dean Bornholt, fired its three oldest administrative staff members, all over the age of 40, in Marist Hall, but kept the 5 younger employees who were all below the age of 40. Again, that fact alone is sufficient to raise a genuine issue of disputed material facts that should have precluded summary judgment on whether the university had shown any sort of discriminatory intent. And so those facts alone should have been sufficient enough to establish a prima facie case of age discrimination, in addition to the facts that we discussed in our brief. But moving on to the second issue, which is pretext for age discrimination. The commission again there erred when it concluded that there were no disputed material facts there. As noted before, the university fired the oldest employees in Marist Hall. But in addition to that, the university's reasoning for firing Ms. GDULA shifted 4 times over the course of these proceedings. Nor does the record support the university's reasoning. As I noted earlier, her supervisor believed that she was qualified to serve in the administrative pool. In addition, Acting Dean Bornholt said that she based Ms. GDULA's termination on performance evaluations, but never consulted her supervisors. And Ms. GDULA received glowing evaluations, and as discussed in the briefing, she was qualified for the administrative pool. There are also other facts, Your Honor. For example, there was witness testimony discussing Acting Dean Bornholt, the decision makers, discriminatory animus to older workers. One witness testified that Bornholt believed older employees were less productive, or dead wood. That witness also recalled multiple statements from Bornholt that the witness believed were a cloak for preference for younger workers. Nor does the fact that the university hired Ms. GDULA while she was in a protected class somehow shielded university's discriminatory intent. For example, in Blunt v. National Center for Tobacco-Free Kids, this court acknowledged that an employer hired an employee in a protected class, but still reversed the grant of summary judgment on the employee's racial discrimination claim. The same should happen here. So for the reasons stated in the briefing as well, the commission improperly granted summary judgment on Ms. GDULA's age discrimination claim because there are, at minimum, disputed material facts relevant to her claim, and this court should vacate the decision below for that reason. Unless the court has any additional questions, I will wait into my rebuttal. Thank you.
I will give you a few minutes in rebuttal. Ms. Johnson, are you going next, or is you're going next? Okay.
I am. Thank you, Your Honor. Good morning. May it please the court. Holly Johnson for the commission. I plan to argue for 5 minutes and then cede the remaining 10 minutes to Catholic University to address the merits. I'm here to address the procedural issues that the commission raised in its brief. There are two independent ways for this court to affirm these procedural issues, the denial of counsel, that have nothing to do with the statute or the regulations. The first is straight up appellate forfeiture. Ms. GDULA never argued in her opening brief that the ALJ abused her discretion by denying the motion for counsel as untimely. That was plainly the grounds on which the ALJ ruled, and that wasn't even mentioned. Timeliness was not even mentioned in the opening brief, and frankly, not really addressed in the reply brief as well. Even then, it would be far too late. And the second ground would be that the ALJ did not abuse discretion by finding that this request was untimely. Of course, the commission recognizes that a request for counsel was made midway through the litigation by two attorneys who were withdrawing their representation, but they didn't clarify what they meant by representation by OHR, and that request was, according to the ALJ's point of view, granted. The ALJ explained in a status conference, I need to explain how representation by OHR works, and Ms. GDULA, who was represented at the time in that status conference, her attorneys never said that was insufficient or that there was something wrong with the relief that was granted, that that was not a proper interpretation of the statute. And then Ms. GDULA never raised that in the interim. And then a new attorney came on. Mr. Cosma represented her from March to May of 2019, never said anything about the interpretation of the statute. And perhaps while he's representing her, that makes sense. But he withdrew. She fired him and he withdrew. And at the withdrawal, he's seeking more time for her to find new counsel. And he never challenged that interpretation of the statute. And then when OHR moved to withdraw months later, Ms. GDULA did not challenge the interpretation of the statute. She waited until litigation was over. And I mean, at that point, as the ALJ noted, litigation had basically been delayed for a year due to her inability to retain counsel that she could work with. And at that point, since she waited till the last minute, it was well within the ALJ's discretion to hold that it was simply an untimely request. So those are two grounds that this court could rule on without ever addressing the merits. As for the regulation, I think that I think there's little distinction between a conclusion that the regulation is unambiguous but is inconsistent with the Human Rights Act, which is not the position we're taking. The position we're taking is that the Human Rights Act does envision the prosecutorial discretion and the possibility that interests may diverge, and that the regulation allows for that. And I'd like, if you'll bear with me, to explain to you how in the text of the regulation you can find that ambiguity. So section 408.4 is the least ambiguous part. The part where it says the case in support of the complaint shall be presented by an agent or attorney of OHR, that part is consistent with the statute and envisions this prosecutorial discretion. And then it says, and this is the language I think that gives this court pause, that the complainant shall designate OHR as the complainant's representative and agent to represent his or her interests. But if you look at how that fits in context, if you'll bear with me, so 408.4 says that the case in support of the complaint must be presented by either an OHR attorney or private counsel. And yet, in 408.2, just two provisions earlier, the regulations say that any individual may represent themselves. The only way to read these harmoniously is to read after the words his or her interests in 408.4, it's sort of an assumption that it's his or her interests in the complaint. So if OHR, if the complainant chooses OHR as a representative, then the complainant has to designate OHR as the representative of his or her interests in the complaint. Or she has to have private counsel representing the complaint. She can't represent the complaint herself because the complaint is a public charge. It is being brought by the public.
What does it mean? What does it mean to represent her interests in the complaint?
I would contend that those are to the extent
That's
her
not
interests.
that's not what it says, but putting that aside.
I'm aware. And yes, I understand. I'm showing you where there is ambiguity.
Where there's a potential ambiguity.
Exactly.
It's odd. If you read that in conjunction with, I mean, I guess before I tell you what to read it in conjunction with, tell me what it means to represent her interests in the complaint.
Well, most of the time, the public interest in the complaint and the individual interest in the complaint are aligned. She has the OHR has an interest
Her
in getting
interest in
her
the
relief.
complaint, I would have thought, is in getting the relief she wants.
Yes, and OHR is trying for that. When OHR represents the complaint, OHR is trying to resolve and provide relief for the individual as well. So most of the time they are aligned. But the interests can diverge. And I want to point you to one other provision in the same section of the regulations that indicates two different lines, like two different divergent interests. And that's 408.5, which
That's
indicates—
what I was going to bring to your attention.
408.5 says that if there is a private attorney representing the complaint, if the individual has brought a private attorney to represent the complaint, OHR may designate that private counsel to act as OHR's attorney in support of the complaint, which means it doesn't have to. Like, the regulation it acknowledges dual interests and that there may be a separation of those interests. And that is enough, especially given the clarity of the statute, to find the ambiguity needed.
Well, you see, I read it. I thought it actually tended to support the opposite position in two respects. First, it suggests that note that it uses the word to act as its attorney. So it suggests to me that when 408.4 refers to the commission being designated as the complainant's representative and agent to represent her interests, it's talking about what we think of as an attorney-client relationship. And the second thought that occurred to me is that when they want to use the word may, they use the word may. When they want to use the word shall, they use the word shall. And in 408.5, they use the word may, meaning the commission has an option whether to be satisfied with the representation of the complainant's attorney or not. In 408.4, it uses the word shall designate, suggesting, if anything, less of an option. Now, that point is less important, I think, to this. But I must say, I've had trouble seeing the ambiguity here, because to me, I read 408.4 as saying that as saying essentially that the complainant shall designate the commission to act as her attorney, in effect, in representing her interests before the commission. It's hard for me to see that as anything but giving the complainant the right to do so. Now, I question the sense of that, because it puts an attorney for the commission in a very odd position of having to represent two masters whose interests may diverge. And I question, though I'm uncertain, whether that is consistent with the statute, which I don't think envisioned something like that. So it could be argued to me that the ALJ actually gave the right advice, even if he read the regulation wrong. But I have to say, the argument that the regulation is ambiguous on this point is, I find it hard to see the real ambiguity. It had to be teased out. I mean, your effort to find it, was valiant, but it wasn't obvious. I think it's fair to say.
I would agree that there are greater ambiguities than this. I've certainly seen regulations that are more ambiguous than this, but especially given the concern that this court has raised regarding whether the regulation is consistent with the statute, it would seem to be more judicious to parse out the meaning of the regulation. Like if the regulation is going to be considered ultra vires, then it's almost like a savings construction. The court should attempt to construe it consistently with the statute
Not
first.
sure why I'd want to save this regulation, but especially since the commission itself is abandoning it. But am I right? This regulation has been on the books for, I forget now, 20 years or so, more than that, I think. Maybe I'm wrong about that. And this is the first time anybody sort of looked at this and says, hey, wait a minute.
So the regulation has been on the books for that long, but it was only in 2017 when OHR looked at the statute and considered its prosecutorial discretion and how important that was. And this apparently comes up a lot, where OHR resolves the public interest or finds that pursuing the complaint is no longer in the public interest.
I would assume so.
So that it was in 2017 that it re-envisioned this. So it may be that it simply hasn't come up. You know, as I say, a lot of the time the interests of the complainant and OHR are fully aligned. So I think that might be why, despite how long the regulation has been on the books, this is only coming up now. I do think that I mean, I think that the court can find ambiguity, but if the court does not want to find ambiguity, there's also an issue of what the remedy would be on remand anyway. The regulation has been changed, and obviously it's only emergency rulemaking at this point, but presumably it would be final by the time this court issues a decision. It certainly has been proposed, final rulemaking has been proposed. It hasn't been proposed to just be an emergency. The new regulation is extremely clear. And as this court is aware, procedural rules tend to apply regardless of when the claim was filed. So I don't see how anything would change on remand. And Ms. Hodge has mentioned that, you know, Ms. GDULA would have a better sense of whether she was represented. But the one thing that is extremely clear from the record, even if this court does not think that she should have raised a challenge earlier to the interpretation, it was very clear that she was not being personally represented, and she's never suggested anything to the contrary.
Does the issuance of the emergency regulation change one of your alternative arguments, which is that if we don't agree with you on the other points, the court should remand the matter to the commission for it to interpret the regulation in the first instance? Does it change that?
I think it does, and that's one of the reasons I wanted to bring this to the court's attention as soon as it was issued. I don't think it's relevant to our top line arguments, but yes, to that alternative argument, because the first thing the commission would have to do on remand is determine whether the question is moot. And so the commission would have to decide under its interpretation of its regulation whether the current regulation would apply or whether somehow Ms. GDULA would be entitled to claw back some entitlement earlier. I suspect they would find that the new one applies, but they haven't had that consideration.
I guess you would have to argue that, look, if you had done what you were supposed to do under our regulation, under that regulation, this is assuming it was valid. If you've done what you were supposed to do, I would have had a lawyer from the commission presenting the case of discrimination for the ALJ. And that's important. I'm really prejudiced by that because it's quite apparent the ALJ did not consider a lot of the evidence, for example, evidence that was marshaled in the letter of determination that supports my position. So the only fair way to rectify that is, regardless of how you've changed your rule going forward, is to, in this case, go back to to where we were and have a commission attorney relitigate the summary judgment motion. I assume that something like that would have to be her position under those circumstances. How do you respond to that?
The commission would need to consider that. I certainly think that would be a valid argument if this court does not agree with the timeliness arguments that we have raised. Of course, in our position is that had she raised this previously, this all could have been resolved earlier and we wouldn't be in this position. But if this court remands on the merits remands on the merits of this procedural question because it finds that she raised it timely and the ALJ abused discretion, then the commission would have to determine essentially which rule applies. And then if it were to find that the old rule applies, then it would have to interpret that in the first instance, which is the reasoned analysis that this court needs before it can decide whether that is valid by giving substantial weight. to the agency's interpretation, because the commission has not yet had an opportunity. I apologize.
Is that concern that the commission have the opportunity to interpret it a concern if we conclude that the regulation is not ambiguous?
No, if this court finds that the
Well, if we
regulation
find
is not
it's not ambiguous, then we don't have to worry about that aspect of this.
no, although the commission would then, I think, or the court would have to determine whether the regulation is valid.
Yes,
Correct.
I assume so. Although no arguments, it's odd because no argument has been made that it's invalid, but.
Well, that's correct. But I will note that most of the commission's arguments have been made almost like fighting against a blank wall because of the appellate forfeiture problems. But the commission would need an opportunity, even though it has amended its regulation. And so I think the court has an inkling of where the commission will go in its interpretation of the statute. This court generally will remand so the agency can analyze the language, structure, or purpose of the statute, and that analysis itself provides a background for this court's analysis.
One thing I noticed in looking at the regulation you sent with your 28K letter is that the regulation was adopted by both OHR and the commission together. Was that also true of the earlier regulation, the one that was in effect at this time? I had thought that the commission was sort of the adjudicatory arm of OHR and that the regulations were OHR regulations. Is that incorrect as to the earlier regulation?
I hadn't noticed that with the new regulation. My understanding had always been the same as yours, that because the commission is an adjudicatory arm, but OHR is the office that's charged with stamping out discrimination. I can't answer your question definitively, though, because I haven't spoken to my client about it and I don't know. I was operating under the same assumption, and I see that now on the new regulation. And I don't know if that's just the caption or if it's officially coming out of both bodies, or I think both bodies have.
That was my read of the new notice.
I think both bodies, I'm trying to remember after I went through the Establishment Acts yesterday, I think both bodies have rulemaking power. So I'm just not sure. I'm sorry, I can't answer that.
Thank you.
So the points, I apologize. I know I've run over my time. So I think I can just leave it there. The commission does not want to lose its opportunity to interpret the statute in the first instance and to interpret its new regulation and its applicability in the first instance, and if need be, interpret its old regulation.
In a follow-up to Judge Thompson's question, is it the commission that would be interpreting the regulation or the office?
It would be
the commission.
It would be the commission, just as because it is the full body of the adjudicatory arm.
Well, I mean, if it didn't adopt the regulation, I would have thought it was OHR, but I don't actually know the answer.
I have the way I envision it, and I'm going to acknowledge that I could be wrong on this, but the way I envision it is that just as the court interprets the statutes, the commission interprets its regulations, and even if they're not the ones that issue the regulations, they're the ones with the expertise over them. So just like the agency can interpret its enabling statute, even though it didn't enact that statute, just because the commission is the adjudicatory body. But I'm not absolutely certain on that, and that is certainly something on remand that we would consider and resolve.
Okay. Thank you. I think we can hear from counsel for Catholic University, the intervener.
Thank you, Your Honor. May it please the court, my name is Yura Peck and I represent the intervener, the Catholic University of America. We have deferred to the Attorney General's office with respect to the procedural arguments regarding representation. And so I'd like to address the merits of the claim, specifically Mrs. GDULA's arguments regarding the prima facie case findings, as well as pretext. I'd just like to address a threshold issue that wasn't discussed so much on the representation issue, which is that Mrs. GDULA's status as a pro se litigant does not entitle her to preferential treatment, nor excuse our obligation to comply with or abide by the commission's rules. Without dispute, Mrs. GDULA did not file a response brief to the motion for summary judgment that was filed by Catholic University before the commission.
Do you think she was prejudiced by not having counsel?
No, Your Honor. I believe that she had equal opportunity and sufficient opportunity to file a response brief in response to our motion for summary judgment. She was
Do you
clearly
think she has
aware.
the skills of a lawyer in marshaling evidence and understanding the law and making the argument that there was a prima facie case and so forth
Yes, Your Honor, I believe that she did have that
without an
capability.
attorney?
She was also guided through the entire process by her husband and her son, who are well-educated individuals. She has demonstrated that she's able to ask for continuances when she needed more time to seek other counsel. She asked for a continuance in order to file objections and responses to the proposed order by the commission prior to the summary judgment order being finalized. So she has certainly demonstrated capabilities in terms of complying with the court's procedural orders. What I found interesting is that throughout this appeal, and even before the commission below, we were given no reason as to why Mrs. GDULA did not file a response to the summary judgment motion that was filed. The consequences of failing to respond were set out right in the brief when we asked for a dismissal with prejudice upon grant of summary judgment by the commission's ALJ. If you didn't want to trust our motion and the request we saw as part of our motion, the commission's rules say that if the commission's rules do not address a specific situation, such as what are the consequences of failing to file a response to a motion, the commission's rule says, look to the DC Superior Court's rules. And if you look to the DC Superior Court's rules, Rule 12IE states that if a statement of opposing points of authorities are not filed within the prescribed time, the court may treat the motion as conceded. So in black and white within the court's rules, as well as within the brief itself that we filed, it was very clear what the consequences may have been if she did not file a response. And yet she failed and decided not to file a response to our motion.
Well, let's focus on whether the ALJ and the commission adequately considered the record before them in granting summary judgment.
I believe that she did, Your Honor. The ALJ, despite not having a response brief or an opposition brief to kind of herald the evidence through the summary judgment stage, she, in her opinion, it's clear that she looked at the record evidence in order to see if there was evidence to either create disputes of fact or as to any of the elements of the prima facie case, or as to whether or not she can establish pretext. If we go back to, let's take a step back and taking these individually, there were two elements of the prima facie case, as Attorney Hodge mentioned, that the ALJ said that Mrs. GDULA failed to prove up in the summary judgment stage. One was her qualifications, and one was the inference of discrimination. Attorney Hodge mentioned several times that the inference of discrimination could be raised from just the fact that the university fired the oldest workers and retained the youngest workers at Marist Hall. Well, this RIF, the reduction in force that's at issue in this case, was not just centered or focused on Marist Hall, one building on the entire campus of the university. It was a university-wide reduction in force that affected all 12 of the colleges that are within the university. Now, if we do take
did the acting dean who made the decision in Ms. GDULA's case, was that the same person who made the decisions for the other 12, for the other 11 colleges?
No, Your Honor, and that
So why do we consider why is it relevant to us in deciding whether the acting dean here made a discriminatory decision?
Because the acting dean
decision was made with regard to the other colleges?
Your Honor, my position would have been that if we're going to narrow the scope of which we're viewing the reduction in force, let's narrow it to the decision maker, which would be the acting dean, Dean Bornholt. But Dean Bornholt had responsibility for more than the departments contained in one building. If you look at the record, which the ALJ did, she concluded that Dean Bornholt also retained employees that are within a similar age group to Mrs. GDULA. She retained employees in their 60s and 50s. So the record shows—
You mean in other buildings?
In other buildings, correct.
Were the circumstances of those employees comparable to the circumstances of the employees here? I thought there were some significant differences.
No, Your Honor, they were all in the academic support group. These are the administrative assistants who supported the various departments within the colleges.
Right, but the question would be, since they were doing a building by building decision because of other constraints on location, you have to look at this. In effect, you'd have to make that other evidence relevant. You'd have to look at the statistical breakdown in each building, and I have the impression that it differs. That this building really has to be looked at on its own terms, in effect. And certainly that's the claim here. Let's just look at this building and see whether discrimination was exercised in the hiring and in the retention and termination of the people in this building. And if that decision was made partially even on the basis of age, then there's a prima facie case. Would you agree?
Yes, Your Honor, but I don't believe that the evidence supports
Let's
that.
focus on this building.
Right.
See, what bothers me about the summary judgment decision of the commission is that it doesn't address, it seems to me, a lot of the evidence, which is marshaled based on, depositions and so forth. A lot of the evidence in the letter of determination that led the OHR to find probable cause. And I would have thought that in order to grant summary judgment, one would at least have to explain why that evidence, which seemed to me to be significant, would not have rolled out summary judgment.
And I think, Your Honor, when you look at the record in its totality, the overwhelming weight of it suggests that or shows that the acting dean at the time she was making these decisions were looking at age-neutral factors. I mean, she testified or stated repeatedly in response to questions from the investigator in the affidavit that she signed in summary of the summary judgment motion, that she was looking at things like function, geographic locations, bus accreditation requirements, redundancy. Those are all age-neutral factors.
Right. Well, the OHR, the letter of determination, took the position that, yeah, we see that that's being said, but we have some problems with that claim. For example, the letter of determination talks about its view, and backs it up, I think, that there are these shifting explanations, and that some of the and that what you've just given was one explanation, but it shifts, over time they give a different explanation. And they did that repeatedly. And the OHR letter of determination points out that some of the things that they claim to have relied on never really came up until after the termination decision was made. Now, I would have thought that those are relevant factors, relevant pieces of evidence, and that if Ms. GDULA perhaps had filed a summary judgment response, or if an opposition, or if an attorney, if the OHR had continued to represent her, it obviously would have, relied on that evidence. And I don't know whether and the commission doesn't seem to have mentioned it in its summary judgment decision. The ALJ doesn't seem to have considered it. I'm sort of, that's an example of why I wonder whether summary judgment was properly granted here. There's stuff in the record that the OHR thought was sufficient to, get it active, and a letter of determination of probable cause, and negotiate a settlement with Catholic University. And yet it's not even mentioned in the summary judgment decision. Don't you think that that's a problem?
No, Your Honor, I don't. I think the commission's review of the record is de novo. It is not required to give any deference to the OHR investigator with respect.
I'm not talking about deference. I'm talking about evidence in the record that's ignored.
I don't believe that the
Not
evidence
with
was. Your Honor, when we look at the evidence regarding Mrs. GDULA's qualifications, for example, even in this appeal, she doesn't point to any record evidence of her qualifications. She claims that she had mastered all the technological changes to her job, but that does not mean she had the skills to be a website maintenance or social media outreach coordinator.
If this gets into the question of pretext, if that was actually the basis of the decision, then and if there were no dispute in the evidence about that, then I grant you that would be a non-discriminatory reason, even if, you know, people could differ about it. If that's their reason, that's their reason. Okay, but what I'm pointing out to you, I think, is that there's a claim here that that's all pretextual, that they made up that stuff later. And the commission, in its letter of determination, offers evidentiary support for that claim. Okay, so that's what I think, and the commission doesn't come to grips with it. The ALJ doesn't discuss it in his summary judgment ruling. And that's just one example. There's other examples, of course. I mean, it's a very comprehensive letter of determination. A lot of evidence that they talk about. So, you know, there's stuff that goes to her qualifications. She may be more qualified. There's some evidence she's more qualified that they, I just wonder how we can support this.
Your Honor, if you look at the record as a whole, for example, you know, there's no dispute that Mrs. GDULA was a valued member of the staff when she was working there. She's the witnesses who have told the investigator that they thought she was qualified for the position. They looked at her qualifications from the aspect of she was a good administrative assistant. She knew how to get things done. She knew who to contact to get things done. She was a very reliable employee. But there's no evidence in the record that says, yes, that she was capable of maintaining a website or doing social media research. There's no evidence in the record that shows that she had any business management backgrounds, which was a specific skill set that was being cultivated in this shared services pool that the university was trying to implement after the reduction. All those, the specific skills and functions that the university was trying to retain, there's no evidence in the record that Mrs. GDULA excelled or was qualified in any of those specific skill sets. Now, she may claim that she was qualified because she's been there for so long and she managed the biggest department in the university. While that may be true, again, we're not looking at the specific skills that could have been transferred from her managing the biggest department to the 5 functions that the university is focused on in this shared services pool, which was website maintenance and social media outreach, faculty advising, graduate and undergraduate student advising, as well as managing the office itself. So they were looking for someone with specific management experience. The record doesn't contain any evidence of that.
Does the record indicate the first time that anybody articulated those 5 skill sets that and this pool notion in which those skill sets would be represented?
My understanding,
I think I remember, it's hard to keep it all in mind, but I think I remember that the claim is that that stuff was first mentioned only after the termination decision had been made. Am I right about that?
I do recall a witness saying that he believed that it was made afterwards, but that witness also was not involved with the RIF process and did not assist the acting dean in any way regarding the RIF process and subsequent actions. The acting dean here in this case was really acting on her own. She did not consult with the department chairs of the various departments that she supervised. She tried to keep it at a very high level in order to make the hard decisions about cuts that needed to be made. So she was not consulting with the department chairs who are supervisors. And that was one of Mrs. GDULA's complaints, was that if it was performance-based, why didn't they talk to her supervisor? Well, part of that was that they didn't want the input of supervisors who, of course, would have been jockeying for position for their own incumbent staff to remain. So the acting dean really acted alone in terms of her decision-making process. My understanding in response to your question about when this the shared services pool was thought of was that it was contemporaneous with her decisions in terms of who she's going to be terminating and who she would not be terminating, because she needed to make sure she retained the skills that would populate this shared services pool.
Who was it who came up with the idea of the shared services pool?
The acting dean, based on her experience with this model at a different university.
And so this is not something that was the basis for decision across the university in the 12 different schools. This was unique to arts and science. What is it? Arts and sciences?
Arts and sciences. That's correct, Your Honor.
Okay.
I'd also like to address the second reason that Mrs. GDULA claims that the summary judgment should be remanded, which is the pretext, evidence of pretext. And I think when you look at the evidence of pretext, again, there were no shifting reasons, Your Honor, in terms of the reason for Mrs. GDULA's termination. She was terminated as part of a reduction in force that occurred in the spring of 2015 at the university. That reduction in force resulted in the involuntary termination of employees ranging from ages 27 to 77. And that was within the School of Arts and Sciences, in all the departments where the acting dean was responsible. So when you look at that age range, 27 to 77, you'll see that some of that's, I know we're using kind of 40 as the cutoff, even though the DC Human Rights Act says that anyone over 18 could be considered for an age discrimination claim. But if you look at the division, you have some below 40 and you have some above 40. And clearly the dean retained employees that are above 40, a number of employees above 40 throughout the School of Arts and Sciences.
Somewhat, yes, there's always the question of what choice she had in other buildings, which is not answered by this record, I don't think. It is striking, not dispositive, but it is by no means, but it is striking that in this particular building, 3 employees who were over, I forget the lowest, 57 or 58, I can't remember the exact number, years of age, were all terminated, and an 18-year gap separates them from the oldest of the 5 employees who were retained, all of whom were under 40. It's, I mean, it could happen. But it's a little bit of a departure from what you'd expect at random, I guess you could say. And so, while I don't suggest it's dispositive, it's a fact you have to reckon with.
And the ALJ actually addressed that specific point. She noted that that GDULA's argument is that 3 of the oldest employees in Marist Hall were terminated, but she also looked through the record to find that one of them was terminated for performance reasons. Another one was terminated because she was a second administrative assistant in that department. And again, we're looking at an age neutral.
Which should not have mattered, which, by the way, should not have mattered if the skill set model we were talking about was actually at issue.
I'm not sure I understand, Your Honor.
I'm sorry, what's that?
I'm
well,
not sure
the fact that under the skill set model, the fact that one of the older employees was terminated, not because she lacked the necessary skill set, but because she happened to be one of 2 people in a particular department, that factor is irrelevant if the skill set model is what they're talking about. It's just a seeming, to me, inconsistency. But
well, Your Honor, the way I would explain it is the fact that she was terminated because she was a second administrative assistant shows that the acting dean was being consistent in terms of applying these neutral factors of looking at operational needs and redundancies within the role. If she was looking at
Under
departments.
under the skill set model, well, I don't want to spend a lot of time on this, but under the skill set model that supposedly was being implemented, each of the people would be working for all the departments in the building. So the fact that you're taking two from one of them is not a problem. You
Well,
see what I'm
she
saying?
had-
And I mean, some of them are not going to have any representation, in fact.
Right, yeah. If you
um,
look at her affidavit, Your Honor, in support of the summary judgment motion, Acting Dean Bornholt, I'm sorry, I keep mispronouncing her name. But the acting dean gives a step-by-step in terms of how she whittled down the number and how she ultimately came to a decision about the who to populate in the shared services pool. She started out with looking at all the departments, looking for the redundancies, eliminating those first, eliminating geographic proximity, then looking at the specific skills retained, or that the specific skills that each of the individual remaining employees retain, and then cutting it based on the skill set to get to that pool that she was looking for. So she gives a step-by-step description of the process that she took. So I see my time is up. So unless there are any other questions, thank you so much for your time this morning.
Okay, thank you. Ms. Am I right? There's nobody else. There's just, we're going back to you, Ms. Hodge. Okay, I just wanted to make sure I wasn't leaving anybody out. Ms. Hodge, go ahead. You have a few minutes in rebuttal.
Thank you. Ms. GDULA was placed in an untenable situation as a pro se litigant who, as this court has recognized, had a right to counsel, at least under the regulation as it was written at the time. But the court need not even reach that issue because the commission erred in granting Catholic University's motion for summary judgment.
Before you
Catholic
jump to that, I'm sorry, Ms. Hodge, to interrupt your rebuttal argument, but I see you moving to the second point. Could you just, could we get your view on the point that Ms. Johnson led with, which is that Ms. GDULA forfeited any, right to challenge the ALJ's rejection of the motion for counsel by, I guess, not addressing the actual basis for that rejection, which is the untimeliness of it?
Your Honor, that argument would be true if Ms. GDULA's argument was that one request was where the commission erred. That is not her argument on appeal. Our argument on appeal is that the entire proceedings were infected by the commission's erroneous interpretation of Section 408.4 of the DC Municipal Regulations. And using the sites that I led with in my opening argument, in each of those instances, when Ms. GDULA requested representation and the commission failed to provide her with representation or only interpreted to provide representation in support of her complaint and not her personally, each of those instances were erroneous interpretations, and that is her argument on appeal, not the very last one. And so that is our response to the forfeiture argument. And unless there are any other questions on that point, I will continue with the merits of the age discrimination claim. Catholic University moved for summary judgment here. It was thus Catholic University's burden to show that there was no genuine dispute of material fact here. But on the record presented, there are genuine issues of material fact in dispute. The university attempts to cloak its discriminatory intent by suggesting that this court view Ms. GDULA's termination in the context of a university-wide reduction in force, but that is not supported by the law or the record. The case the university cites, Simpson, actually supports viewing the termination in context of Marist Hall rather than the entire university. And it is also far from clear whether the qualifications for that administrative pool at issue here were the qualifications the university offered. Rather than go through each of the shifting rationales the university gave, I will instead give the court the record sites where it can find each of these shifting rationales. The first rationale that the university gave can be found on page 29 of the joint appendix. You can then find the second iteration of the rationale on pages 21, 24, and 29 of the Joint Appendix. Your Honor, I see that my time is out. I can stop here, or I can give you the remainder of the slides. I would like to be
You can
respectful.
give us the remainder of the slide.
Thank you. You can find the third version of the shifting rationale on page 29 of the Joint Appendix. And it's then on page 347 that you then find this latest iteration of the reasoning for terminating Ms. GDULA, which is the one that includes the social media outreach, website maintenance, et cetera. And so unless the court has any additional questions, I will end by requesting that this court vacate the commission's order, remand for an evidentiary hearing, and instruct the Office of Human Rights to comply with Section 408.4 by providing Ms. GDULA with representation. Thank you.
Counsel, thank you both very much. The case is now submitted, and you all may log off.
This court is now adjourned